Good afternoon, everyone. Welcome to the Bylaw Review Subcommittee meeting. Before we begin, if you're able, please stand for the acknowledgement of traditional lands. We acknowledge we are hosted on the lands of the Mississaugas of the Anishinaabe, the Haudenosaunee Confederacy, and the Wendat. We also recognize the enduring presence of all First Nation, Métis, and Inuit peoples. Thank you so much. May I have a motion, please, to approve the agenda?
Trustee Williams.
Thank you very much, Trustee Williams. A seconder, please. Thank you, Trustee McLean. All in favor, please say aye.
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 Thank you so much. Is Trustee King on the line?
Yes, I am here. Thank you.
Thank you so much. I just wanted to confirm that all the members are here, and thank you to anyone else that is also joining us. Are there any declarations of possible conflict of interest? Hearing and seeing none, are there any delegations today? Thank you very much. So now I think we'll get into the business of the meeting, and with the indulgence of the committee members, I hope maybe to make this just a little bit less formal so we can have good discussions and conversations. So we'll do our best to obviously play by the rules, but maybe with some flexibility so we can actually have good discussions with staff and not make it so formal, so we can attempt to reach consensus on these items. So I'm going to go now to Associate Director Pon, please.
Good afternoon. I'm very pleased to present some of the work that we've been doing on the complaint procedure. But before that, there is item number 5, project timeline. Did you want to address that first?
Certainly, okay. I will address timeline first.
Okay.
So this is a timeline that was prepared by staff to give a sense of the work ahead of us and some perspective timelines to this work. I'm wondering if my colleagues have any comment. I'm not hearing any. So for now, this is the timeline I believe that we will work towards. There may be some hiccups along the way and some things might take us a little bit longer, but I appreciate the work of staff to give trustees a sense of the work of this committee. So thank you very much. Do we need a motion to receive it? No, it's for information. Mm-hmm. Thank you so much. So now we'll go to our presentation, please. Thank you.
Thank you very much. And I do want to thank Vitaly Plotnikov for all the work, not only with the project timeline, but also with this complaint protocol. As the committee has indicated, this is a priority item for the committee, just given the timeline. So we have prepared a brief slide presentation just to describe some of the major changes that we have in our draft protocol. And so you recall in the previous meetings, we provided overview of what the major changes are. We then talked about some of the potential issues and areas where we may need to get additional input on. What you have in the agenda material is our first attempt at capturing this draft protocol based on feedback so far. There are some areas that I think, and we've indicated in the slide deck, where additional conversation amongst the trustees will be required in order to complete the actual complaint procedure. So if we can just go to the next slide. And again, I won't go into details for this, but as you know, many of these changes are required under the changes to the Education Act. The Code of Conduct, TDSB was one of the first school boards to come out with one, an integrity commissioner process. The rest of the school boards are now required to do something similar. So if you can go to the next slide, please. This slide just provides a summary of some of the key revisions that we've made compared to the previous, the previous Code of Conduct. We will touch upon a few of them. Many of the changes that we have prepared in draft just reflect the requirements of the legislation and also reflects as much as we could what was in the previous code of conduct to avoid such a significant change and provide some consistency. Next slide, please. This table really is to assist us in understanding better the complaint process that's anticipated under the regulation. And again, as I mentioned before, the old TDSB Code of Conduct included complaints from staff and public. And what we have done here, which will be different than what you've seen in the past, is that, of course, trustees can file the complaint. Complaints from staff and members of the public will have to be submitted or carried by a trustee to line up with the regulation and the expectations under this new process. The second column really, and that email has not been set up, and it might not be the exact email, but this was a prototype of the process where we can imagine intake would be through email. The distribution will be done in accordance with the regulation, and there are quite a few people who require distribution. Columns 3 and 4. Columns 3 talk about who should be receiving it. Again, the email address should assist with receiving it. I should note that when we talk about a complaint recipient in the draft, we are not referring to the trustee against whom a complaint is made. The regulation has required that a trustee or the chair receive the complaint. And so just we wanted to make sure that people are clear about that delineation. The informal resolution period of 20 business days, we can talk about what happens during that period of time. And then the last 3 columns really is the integrity commissioner piece that has significantly changed from our old process. And it's quite self-evident there. There is at the very last piece, again, a potential for a trustee or the board to appeal to a 3-person panel that the ministry sets up. So that's it at a glance. Next slide, please.
Do you want us to hold questions or?
Actually, what would be helpful?
If you don't mind holding it, it will complete
I'll put
very
you on the
soon.
list, trustee.
Thank you very much.
Thank you.
So one of the key areas we want to talk about is the notification of alleged breach code of conduct. We are contemplating a central intake process through an email that is staffed appropriately. You'll see the distribution of the complaint. Ultimately, the entire board of trustees will receive a copy of the complaint and the 20 days to try to resolve. Next slide, please. The integrity commissioner will undertake their initial threshold assessment. So there is a provision in the regulation that allows them to refuse certain types of complaints, primarily those that are what they consider late. And so under regulation and our policy, 60 days in order to have a timely complaint. And then other areas, if the IC determines it's in bad faith, frivolous or vexatious. And the integrity commissioner makes a decision on whether to investigate, and that decision is final. And there is a timeline for the integrity commissioner to do an investigation and determine findings. Of course, there's an opportunity to seek an extension as well. Next slide, please. This is a summary of the new sanctions that the integrity commissioner has the authority to issue. Everything from censuring the member, which may be familiar under the old provisions, to new things such as reducing an honorarium or returning repayment of it. Other barring the member from exercising the privileges of a board member or acting as a board representative. I don't have any information on what exactly that means. And then any other sanction that the IC believes would promote compliance with the code of conduct. So as you can see, the language is actually quite broad. And we would look forward to additional information from the ministry on what those actually mean. So next slide, please. Thank you. The appeal process that's contemplated, it's either the respondent trustee, so the person of whom the complaint is against, or the board can appeal the decision of the integrity commissioner. There are some timelines associated. It will have to be in writing. The appeal panels established by the Ministry of Education, there is a timeline for which they are to make a decision. My understanding is the appeal's entirely in writing. Next slide, please. Appeal process is in writing, sorry. All right, so one of the areas where we had quite a bit of discussion about is what is the role of the trustee or the chair or the vice chair, depending on who's receiving it, to do with the complaint. So what role should they have? Would they normally be the kind of the intermediary and move it from place A to place B? Should they engage in some sort of effort to try to resolve? Should it be left open to whoever is the trustee who receives the complaint? I should also note that for trustees who are receiving a request from a staff member or a member of the public to carry a complaint, what role, if any, should that trustee have? So perhaps I can refer it to the chair to have some discussion on that point.
Maybe if you don't mind,
Sure.
would you go through the deck about what the other discussion
Sure.
points would be so that trustees get an idea of all the things that
Absolutely.
you need support with help with? And then we'll stop there for a minute, go to questions, and then we'll start the discussion if
Okay.
that's okay.
That's amazing.
So
Thank you.
if you can go through the next discussion point where you need our support.
Okay, thank you. So discussion number one is what is the role of the receiving trustee? Next slide, thank you. We have put in the draft what if there is a role for the trustee, what would they do? Right now, the language in there is the trustee would assess the complaint on reasonable grounds. So the question here is, what is the role of the trustee who receives information about alleged breach of the code from staff or members of the public? How will a trustee make an assessment on reasonable grounds? Is there criteria to consider? There can also be another question here is whether there should be any reference to reasonable grounds at all, and whether the trustee is mainly helping carry it from place A to place B. Next discussion, next slide. So in our current, in our old code of conduct, again, TDSB being one of the first to come out with the code of conduct with integrity commissioner procedure, there were several provisions relating to the payment of costs of trustees who are facing integrity commissioner complaint, namely legal costs. There are two levels contemplated under the old code. One is really to address complaints, up to $5,000. If there is a judicial review application of the finding of the board, remember the old procedure, it's the board who made the determination. There is potential for reimbursement up to $20,000. This, under the old code, there were some criteria, and the criteria included a finding that there was no breach in order to be eligible for reimbursement. If you can, should the provisions of the old code pertaining to legal costs be maintained in its form, in a different form, and a source of funding should be identified. We have attempted to find some information on if there has been any type of reference or claim made against for this. We are not aware of any at this point in time. Next slide, please. And again, additional provisions from the current code on legal reimbursement. Next slide, please. There was a request at a prior meeting on information about Integrity Commissioner costs. We have attempted to break down the information that we were able to gather and did consult with the Integrity Commissioner. And so you'll see from the 22-23 time period, 14 complaints were processed. And remember, these were complaints that were processed, not necessarily investigations. The total costs charged by the Integrity Commissioner for that time period was $57,000. And for the most recent complete year, for 23-24, 12 complaints were processed. Some of them were investigated, 5 were abandoned or withdrawn, and close just above $80,000. And hopefully this provides some information to assist. Next slide, please. And those, that's our presentation, so we're open to questions. Thank you.
Thank you very much, Associate Director, and to Vitaly and the policy staff for setting out the context. So before we go to the discussion points, we'll take some questions just on the overall, and first up is Trustee McLean.
Thank you, and through the chair. We are going to discuss the role of the initial trustee in there, so I had questions about that. So
Sure.
I'll kind of get away from that for now and wait for that discussion. The need to notify the trustees and the board and whatnot, and for this to become public, is it if it comes to the chair and the chair agrees to mediate, and through that mediation comes to a resolution so that it doesn't have to advance to the Integrity Commissioner, is it necessary? Is it still like, has it reached the threshold in which that this information needs to be shared, or is that after, or, you know, that?
Through the chair, the regulation actually spells out the distribution to the Director of Education, all the members of the board. Ideally, before a complaint is filed, once that process is triggered, you'll see the distribution is required. If there's a way to resolve it before a complaint is filed, I think we can avoid having that, have that complaint distributed. So maybe some focus on pre-complaint resolution would be very helpful.
But I guess this gets down to what constitutes filed. Is it filed when it leaves the chair, the vice chair's hands and is given to the Integrity Commissioner? Or is it filed as soon as one trustee is willing? And we'll get to that but as soon as it's drawn up, it's the complainant signs the document. Is it now live? And then because now we currently only see, we only see what the Integrity Commissioner, we get a very limited scope of what the Integrity Commissioner deals with. This would be suggesting to broaden the scope of that at a time when it's narrowing our role. Like it's, we're giving away all the authority that we have, but this seems to be more about public shaming than, so I'm curious about that.
Through the chair, in my view, and again, the trustees can fashion the procedure in a way they like. Once it's filed with the email account or handed over to a trustee in the form of a complaint, that starts the entire process. What we have not built into the draft, although something you just mentioned that the board may want to consider, that we can in fact do if we want, is to put a pre-complaint procedure to try to handle that very informally, has nothing to do with the regulations or the Education Act. It's a built-in informal way for whoever, trustees, to try to resolve it. That's something that you can consider. And again, if we pass this again, because we are having to do this in a more timely fashion, we can always maybe think about that a little further and how that would look like. I think it's not unusual for many of these complaint procedures to have a more informal complaint resolution stage before it triggers a complaint. So that's something that we can consider adding. Stage 0, essentially.
Okay, thank you.
Thank you very much. May I pass the chair to you, please?
Yeah, please go ahead.
Thank you very much. Just following up on that, I would absolutely like to see in the procedures before 6.1 notification of an alleged breach of code of conduct. The first thing under that would be something about, should a trustee bring a complaint or be the vessel of a complaint? The first step would be to X prior to the formal submit notification of alleged breach. So I do think it would be helpful if there was at least one step, whether it's a conversation with the chair or the chair has a conversation or something to think about. I think that would be really important. But my overall question is, what about confidentiality? Nothing in this whole procedure speaks to confidentiality. So in the current process, every single thing is confidential. In fact, even if you've been accused of a breach and that never goes anywhere, you're not supposed to even talk about that. Nobody would ever know you were accused of a breach. In this particular process, it's like the whole world knows that you've been accused of a breach. Is everything continue to be confidential? Is my overarching question. Can the board make that determination that from the central intake process through the notifications, that's all confidential? The only thing that would ever be reported in public would be similar to what happens now.
Mhm.
And that's when there is a decision of the integrity commissioner. Now it comes as a recommendation to board and public. But through you, Mr. Chair, I'd really like staff to be clear on, we have the ability to keep all of this still completely confidential to protect the board, frankly. Because, if a complaint is made and it seemed to be frivolous or not of merit to follow further than the chair receiving it, I would not like to see the particular trustee, because it may be against a particular trustee, but it still brings the board itself as an institution into repute. And this already seems, my personal opinion is this legislation seems to be very, it really brings trustees to a completely different level than any other elected official throughout this province. And I think that in itself is being done purposeful. And I personally would like to see everything we can do through you, Mr. Chair, to staff, is to keep the integrity of the process. Obviously, if trustees have broken the code, there should be consequences for that. Trustees should follow the code. It's our code. But I believe the confidentiality of this is really important. So through you, Mr. Chair, to staff, there is nothing about confidentiality right now in the procedures, and I'm wondering what staff's thought is on that. Through you, Mr. Chair.
Through the chair, I think that is an excellent suggestion. It's again up to the committee, I guess, to make the recommendation. We can update the next draft to include confidentiality as far as we can. And once it gets into the hands of the integrity commissioner, that's the process that they have to deal with. just wanted to seek clarification, maintain confidentiality. This applies to all parties. So the complainant, whether it's a member of the public or staff or the trustee who's complaining, the responding trustee as well, and anyone else, because all board members will eventually receive a copy of it. They will also have a duty of confidentiality as well.
Correct. Thank you, Mr. Chair. Thank you for that consideration. I would really like to see that built in. I'll take the chair back and we'll go to Trustee Arts.
Hi, thanks. Through you, Madam Chair. Yeah, I think clearly defining the confidentiality process or like ahead of an individual trustee forwarding a complaint. I think the confidentiality has to be really clear because like we do want board members to be protected, but we also want staff or the public to be protected. And I think if we're not really tight and clear with what an individual trustee is supposed to do, that the opportunity for missteps or abuse, you know, we just could open up everybody to unnecessary risk. And like I know right now with our, or in the past with our integrity commissioner, if as a trustee you wanted anything other than, you know, some background advice and some clarifications, then you have to sign a confidentiality agreement before starting anything. So I think that's really important. I think, I don't know, I think it has to be quite straightforward and that the receiving trustee is going to receive and pass on a complaint. Because I think that also opens up risk if somebody, you know, thinks they can take it upon themselves to be judge and jury. And so a pre-submission protocol, I don't know, like, I don't know if you receive a complaint as a trustee, step one, you refer it to the chair. And then the chair has, you know, or the vice chair, and then they have a mediation process that is engaged in. I think that will also help with tracking, like not just having like it'll enter it into a formal process, then will also be properly tracked. So I think if it's simple, you receive a complaint, here's how you report it to the chair, copy this email address, then this is the exploratory or pre-mediation. I think would be a best protocol for everybody. And my understanding from discussions, so my understanding with discussions at OPSPA and provincially in the advice that other boards have gotten and OPSPA has gotten is that the ministry expects us to solve our own problems and not be, you know, automatically jumping into a formal complaints process that's going to go to integrity commissioner. I think there is a big expectation. It sounds like what's been conveyed is there is a big expectation for us to work through our own issues. And while they're going to put together a roster and things can go there, the legislation was written so that the public, let's say the public, can't just go directly to an integrity commissioner, especially for vexatious pieces and, you know, and drive up costs. So thanks.
Thank you very much. We'll come back to some of your points when we discuss the first discussion point. appreciated. Trustee King, please go ahead.
Thank you, through you, Chair. A couple of thoughts on the points my colleagues have raised, and then one that I observed in my reading. So just thinking about the possible pre-complaint process and the mediation and what Trustee Arts has just shared about the expectation for us to really be resolving our own issues. I wonder about the skill set or support that might be needed to facilitate that. I think there are certainly some cases where our chair would be more than equipped to do that. But we don't know what kind of complaints necessarily are coming, and that chair role will change year to year. So I think it's important that we're thinking about how they're set up for support to actually accomplish that, especially given different relationships and certain dynamics, I think that could come into play. We also talked about confidentiality, and I agree with all the points that you raised, Trustee Laskin and other colleagues. One of the things that I think is important here is, and I brought this up in our first meeting, I think it's important that we're able to capture and understand and reflect on some of what's happening as this process moves forward. And I'm not sure yet what that balance looks like between confidentiality for all the reasons that you've said. Like, this can't be a witch hunt for trustees, and we can't be documenting in a way that enables that. But I do think there might be value in understanding how many complaints we're able to resolve successfully on our own before going to IC. I think it's important to understand if there are certain complainants always coming forward or certain trustees often having complaints brought to them. I think there's value in understanding what's happening, but not all of that might be public facing. So I think that's something to think about as well. And then something that caught my eye just reading through is the top of the policy has a number of definitions included. And one of the things that we talk about through the document is bad faith, frivolous, and vexatious. However, those are not defined. I'm wondering if that might be important and helpful to have either a definition and or even examples somewhere along the way of what constitutes bad faith, frivolous, and vexatious. And those are my thoughts for now.
Thank you very much, Associate Director. Did you want to comment?
Thank you very much. With respect to the last question about adding definitions of bad faith, frivolous, and vexatious, we can, in order to help explain this procedure, whether the Integrity Commissioner uses that exact same definition in order to do their initial screening. I don't believe it's within our purview to require that, but I think it's an excellent point so that people can understand what these words mean, because they're actually not quite self-evident. So we will add that as well. And I appreciate the other points that were made as well.
Thank you very much. Trustee Williams.
Thank you, and through you, Madam Chair. I couldn't agree more with the concerns that were expressed by my colleagues regarding confidentiality and that need for some kind of pre-complaint process. I guess the question I had on those comments was that if such a pre-complaint process would be inclusive of the 20 days, the 20 business days that the regulation speaks about, or if it could be outside of those 20 days, just a little bit of clarity there. And my next question, probably might be for a further future discussion when we get into more detail. I like the idea of the trustee who receives the complaint forwarding it on to the chair or vice chair. But in the circumstance where it's a complaint against the chair or vice chair of the board, like, a possibility or a suggestion of having a designated trustee for receiving such complaints. And for example, that designated trustee could be, appointed, elected at an org board. It's just an idea, but it's like more of an operational detail that might be, come up in further discussion. So those are my two initial questions and my comment.
Thank you very much. Please, do you have anything to add? Thank you.
Thank you very much. In terms of the pre-complaint process that we're thinking about, really, this is, the chart that you saw on the screen. It's before the chart even exists. And so the 20 days is not really impacted by this. One of the concerns I do have is the regulation makes it very clear you have 60 days from the day of the event issue, the breach that you think it is, in order to file it. What we don't want to do is inadvertently stretch the time out either. So I can tell you with the Human Rights Tribunal, many complainants have who filed late applications that, well, we were engaging in mediation and therefore the time should be extended. The tribunal does not regard that as a proper way to go beyond the timeline. So regardless of what happens before that complaint is actually sent to that trustee complaint at TDSB email account, that informal pre-complaint stage, it would be up to the complainant to make sure they file the complaint on time in order to be timely. So hopefully that helps with that particular piece. With respect to a designated trustee to receive, that can be done. I do think some complainants, regardless of whether it's a trustee staff or a member of the public, may not feel comfortable with that individual. Is there an election process for that? What type of additional training? How much time would it take? So again, not for staff to decide, but I just wanted to share with you where there may be some challenges with designating a trustee.
Thank you very much. We're into the second round of questions before the discussion. Trustee McLean, please go ahead.
Thank you, and through the chair. I was taken by Trustee Art's her sharing of what is understood to be the government's position in that, that they want us to look after, and they're not looking, which surprises me, to be quite frankly, because the point of this seems to be to take it away from us and make it more formal and have us with less mechanisms in this. So to that end, I'm going to kind of double back to my first question, and that around mediation, when we talked about mediation previously, it was described that successful mediation would be determined as a withdrawal of the complaint, that there would be, the parties would agree and the complaint would have deemed to have been withdrawn. Can we confirm, I guess, with the government or with whoever legal sources, and I appreciate that you're a lawyer, so I'm not sure if this question begins and ends with you, but where exactly the line is, and because I think that a process that determined that the complaint wasn't, until it left the chair and deemed to be going to the integrity commissioner, that it didn't necessarily need to then meet the distribution things, and that mediation could count as our pre-process, and that we wouldn't get caught in this time. But that would only kind of work if we believed that the process didn't really begin until the chair concluded that they were unsuccessful. Either it was too big that they didn't think that they could try, or they tried and were unsuccessful, and at that point, we knocked over a domino and then it ran. But so I guess I'd like clarity that what actually has to take place, if all that has to take place is a complainant signature on an initial document, is that's all that needs to take place to make a formal complaint, or does the chair's or does the chair's actions then determine the complaint, because it would then go to the integrity commissioner?
Through the chair, the complaint starts once the notice of complaint is filed. So emailed, if you decide on a central email intake, then once it's put in there, that's when the complaint starts. The trustee who receives it, so let's say it's the chair in that particular case, there's nothing in the regulation that says the trustee must do something. Sorry, the chair must do something other than to make sure it's forwarded to the integrity commissioner within 20 days. So we added some provisions about, what if something is successful during the 20 days, the complainant does not want to move forward with it. So normally when I'm looking at other tribunals that I have worked with, usually it's a withdrawal. So the complainant decides they're not going to move forward with it, or they abandon it. So let's say the chair does what the chair is supposed to do under the regulations, which is to simply send it over to the integrity commissioner within 20 business days. If you don't hear from the complainant anymore, or they decided, I'm okay, I don't want to do it anymore, they should be notifying the process, or providing some sort of notification that they're no longer proceeding with it. You can include some sort of informal mediation before the complaint is actually filed. I've seen in some cases, someone files a complaint. In order to meet the 60-day deadline, the matter might be forwarded to the integrity commissioner within 20 business days. However, in the meantime, they may be trying to work it out with the trustee that they're complaining about. And that might kind of extend some timelines. The integrity commissioner may receive a request to just hold off on their investigation if they feel that there's enough things that are going on. So there's a lot of flexibility in what I've seen in similar types of complaint processes. And again, building an ADR, an alternative dispute resolution process, before someone actually puts their name and signs their name and sends it to that email account is probably worth exploring further.
Okay, thank you. And through the chair, then I'll kind of pivot. Things that matters that the chair was able to successfully mediate. Okay. So we're going to have already notified the director and the other trustees that the complaint was launched. Does the same sort of level of distribution go with the withdrawal, the ultimately mediated withdrawal? And do the details of the withdrawal, are they relevant in the level of distribution? Like how forthcoming and transparent is this process?
Through the chair, there's no requirement under the regulation to share any of that information with the board of trustees. The only requirement is just the distribution of the complaint once it comes in. And that's the only thing that is required under this. So whether you want to add a provision that says like there's no further distribution, essentially, right? So remember, the only distribution is at the very beginning once the complaint comes in. That can be done. I should also mention, aside from withdrawing complaint and abandoning the complaint, what I've seen in other type of processes is a settlement of a complaint. And so let's say I don't know how formal we want to go in this particular stage, but normally when I handle grievances, human rights tribunal applications, labor board applications, any type of tribunal that I've worked with, there's a document that sets out the settlement, right? So complainant agrees to withdraw. There may be an apology, who knows? Like whatever the terms are of the settlement. And I think that's goes back to the point trustee Arts, one of the previous trustees raised, perhaps trustee King raised about the training of a trustee who is involved in trying to resolve this. I do agree. There should be some sort of support for that trustee. And at the same time, I do want to make it very, very clear. The regulation does not currently require the chair to do anything during the 20-day period, just simply refer it to the IC. So whether the trustees want the chair to engage in some sort of resolution role, again, entirely up to the Board of Trustees to do that.
Okay, thank you. And I'll follow up through the chair. If it's the government's expectation that we're going to, how do we deal with it locally? How do we deal with our own issues if all the chair does is, rubber stamp and hand along? Like, I'm not sure how what they've given us seems to match with their intent.
Through the chair, recall many school boards did not have the same type of integrity commission process we had. So for them, and if you have the chart that was up there, essentially the left half of the chart, if you split in the middle, is that pre part. It's the pre part. We're working with something we already had, but adjusting it for the new regulations. I can't really comment about the contents of the regulation. In my experience and I've been doing labor relations for over 25 years, having a more public distribution of the complaint before you actually try to resolve it is odd. Like, it's very, very odd. It should be the two parties who have the dispute to try to resolve it, even themselves, with the help of someone else, doesn't matter. But in any event, this is what we're been given to work with. Thank you very much. Yeah, so the first four columns, essentially that is what the regulation contemplates as the local board attempt to informally resolve the complaint before it goes to the IC. So they've built in their eyes what they thought was a process that would allow us to try to resolve it. It's column number 2 I find is very challenging to deal with if you're trying to resolve it, other than, as you mentioned, to apply some peer pressure.
Okay, and through the chair, just so I'm trying, if we're going to, assuming we keep this mediation option open for the chair, does the chair have the ability to reach out to the integrity commissioner for advice, or does that would that taint the process? And if he can't reach out to the integrity commissioner, does he or she have the ability to reach out to our legal staff to try to, determine, should I fix, this seems vexatious to me. I don't want to give it, I don't want to enter the process. I believe that it is, I believe that I'll pass it along. But you don't want to kind of if you can make it go away by just some effective mediation, you don't want to you don't want to lose the opportunity necessarily. So would they have the opportunity either in-house to confer?
Through the chair, that's a really excellent question. My preference is that TDSB legal staff are not involved in providing advice. Just it's not a good situation for in-house lawyers to be involved with. If there is access to an outside lawyer to provide advice to the chair, I would suggest it would be a board retained lawyer. So the board has their own lawyer for employment law, for example. And so maybe it could be the same person or another individual. That's fine. And do recall, the regulation does not require the chair to do anything other than to forward it within 20 days. If there is a requirement that you want to add to have the trustee who received the complaint, let's say from a staff member or the chair who receives the complaint from a trustee, to do a little bit of vetting for reasonableness, to try to deal with it up front, I think you're going to have a significant challenge. So what I would recommend is there is no vetting for a trustee to trustee complaint. Whether you want to have a vetting for public or staff members is up to you. However, the trustee who engages in that type of vetting will have some risk, I have to say, and a significant responsibility that their vetting is properly done. And they can seek legal advice if they wish. My recommendation to you is that whoever's receiving it from a staff member or member of the public would not be vetting it, essentially. It's handing it over to the next process. Let the IC vet it for bad faith, vexatious, and frivolous. They have the training to do that. You don't want to put yourself under unnecessary risk, in my point of view. But again, this is the decision of the trustees. Thank you.
Thank you.
Thank you, Trustee Arts. And then I have myself. If anyone else wants to be on the list before we actually try to solve that discussion, option number 1, please let me know. Trustee Arts, please go ahead.
Thank you. Through you, Madam Chair. I'll start with Trustee McLean's comment. I don't think the ministry meant to be like, charitable to boards with this or not. I think my takeaway from all the discussions has been, this is a get your house in order, stop behaving badly. And if you can't fix it yourselves, then we've actually given integrity commissioners independent power to fix your crap for you. I think it's really intended as like a shot over the bow, because there are some trustees who are very, very publicly badly behaved. These are not like happening in schools. One of the boards is dealing with one where the trustee took a meeting from the bath. And so there's a lot of very public things that are happening in the papers that it's to both of them. And then as was mentioned, there's lots of boards don't have integrity commissioners. They actually deal with the complaints themselves within the board. And there's legal fights happening right now between trustee members and boards that are also very public. So it's not the majority of boards, but where it's a mess, it's very public. And I really got the sense that this is a, having heard from the ministry, this is a behave well and, work with your colleagues, and try and get organized and be better. And then if you absolutely can't do that, then here's a tougher process to incentivize you on the back end, I guess. So just a question, the 60 days, is that 60 days from the time of the occurrence to refer it to the integrity commissioner, or would filing a complaint or contacting the board about a complaint be you know, if somebody came and said, I have a complaint, I explore this, could that be a timestamp to say that they've acted within the 60 days?
Please go ahead.
Through the chair, so it's 60 days after, and this, I'm referring to 6.2.3 subsection A, and then eventually subsection, 6.2.4. So under A, the complaint was made more than 60 days after the day of the alleged breach occurred or was discovered, whichever is later.
So someone contacting, if we set up a central intake, somebody contacting with a verbal, I would like to explore a complaint, would then formally be within the 60 days.
It could only be a trustee.
Through the chair, there, and again, this is for the integrity commissioner to decide whether or not to investigate.
Right.
If something, this is why the time period matters. So if something is beyond 60, let's say it's 70 days, then the integrity commissioner can actually say, I'm not going to investigate this because it's 70 days out. You didn't fit it within the time period. Please also take a look at 6.2.4. So if it's a series of breaches, it's from the date of the last incident of the series. So for example, in the labor relations realm, we see this often if someone's constantly being underpaid in their biweekly pay. So that's a series of breaches. So it runs from the last time you had your pay. So that similar type of thinking is happening in this particular case.
Okay, thank you.
Thank you very much. May I pass the chair to you, Vice Chair McLean?
Yeah,
Thank you.
please go ahead.
So it seems to me, if you look at the chart, what we're really wanting is the informal process to begin without a formal complaint moved. Because once a formal complaint is enacted, even though this contemplates resolving it informally, it's still notice is given, et cetera. The legislation comes into play. So potentially, one could consider, and it's only a trustee that can send an email to the central intake because it's only a trustee that can make a complaint. So potentially, and I've obviously not thought this through, but perhaps we can make the pre-formal complaint process, whatever we want to call that, consideration of filing a formal complaint or something. If one is considering filing a formal complaint, whether it's trustee to trustee, public brings it to trustee, or staff bring it to trustee, the first step potentially would be to inform the chair, who could trigger mediation. I mean, I'm making all this up, and have 20 days to resolve it. And the caveat would be, instead of within 60 days of the occurrence happening, the informal consideration of a complaint would have to happen within 30 days of a complaint considering. So you don't mess up the actual formal complaint process, because you could still give it another go for informal as part of the formal complaint process, but you at least give an opportunity. And you know, I am mindful of additional costs to the board. I support the fact that our legal should not be involved, because that is too tricky in terms of who you actually support, whether it's a trustee or the corporate board. But I'm just thinking that could be something worth exploring. And then the other point, and this is where I think Trustee Arts, we've talked about this through the OPSPA policy work group team. Many boards don't have integrity commissioners, and what they used to do at their organizational boards is they would make a discipline committee, and that would be a formal committee of the board, of which people would, put their hand up to be on. I think it was 3. I think it did involve the chair and the vice chair. We could consider something similar as a chairs committee. Like, these are the chairs are people that the board has given leadership responsibility to. That could be another group formally established that could support the chair and the vice chair in informal conversation. And obviously, if you were involved in the complaint by either bringing it or being the recipient of it, you wouldn't participate in that. So I think there could be some creative solutions to getting us to not wanting to begin the formal process by which this is all distributed, and we're concerned about the reputation not only of individual trustees, because these are all alleged at the very beginning of any process, or the corporate board. You know, I don't want to see the article in the Toronto Sun to say that, the Toronto board has had 27 complaints in the last 6 days about, but I expect that this is the kind of headline that people will be most interested in. So I do think there is some conversation. There seems to be some consensus around a pre-process, whatever that might be, before it triggers the trustee actually sending an email to the central intake. And I think I'll stop there. Is there, through you, Mr. Chair, I can take the chair back. And is there any other comments before we get to the discussion item? I'm mindful of the time. That was a great conversation. And I think we've talked a lot actually about, we've kind of skirted around that first question anyway, but I do see Trustee Williams, please go ahead.
Thank you. And through you, Madam Chair. So just a question. There was a remark earlier about trustees being involved in a vetting process that could put them at risk when it's a staff or public complaint. So I'm just wondering, with regard to Trustee Laskin's comments, that would be more relevant to a trustee complaint. I guess my question is, how would that risk be mitigated if the complaint is, from staff or public? With regard to a trustee, or a committee of trustees vetting.
Through the chair, the trustee who receives the complaint from a staff member or a member of the public can always attempt to try to resolve it if they wish. What I don't recommend is being the gatekeeper. I don't recommend a trustee who's being asked to receive a complaint and carry it forward for a member of the public or staff to say yes or no. Because if the answer is no, and the reasons are not solid, there could be a challenge to the reason that the trustee applied to prevent a complaint from going forward. And whether this is ombuds, whether this is something else. So for example, someone says, oh, you decline to help me carry it forward because I have a disability, then there's a risk for a human rights tribunal. There are other types of non-legal risks as well. So to me, again, my recommendation when it comes to staff and public complaints is at the very most an informal attempt to try to resolve it. However, there should be no role in my recommendation to you to prevent something from moving forward. Let the integrity commissioner handle that piece.
Anything further, Trustee Williams?
Okay, thank you. Through the chair. No, thank you.
So I think we're actually on the option one about the notice of the complaint recipient is not expected to engage in mediation to resolve the complaint. They may engage in mediation to resolve the complaint, or the chair or the vice chair's notice of complaint recipients may engage to resolve the complaint. So perhaps you could just lead us through with a little more clarity into exactly the difference between these options. Thank you.
Thank you very much. Could I ask our friends to just move to the slide that says discussion topic number 1? There we go. Again, what role should the receiving trustee play or have, sorry. We already talked about a trustee to trustee complaint. The chair may or may not have some sort of role to play to try to resolve it. For members of, so complaints coming from staff members or members of the public. Let's say I approach trustee McLean, I have a complaint. My recommendation is trustee McLean will be within, we'll be sending it to the trustee complaints at tdsb.on.ca email account. And then the staff who are monitoring that will again make sure that the distribution occurs, and then it's forwarded to the integrity commissioner within 20 days. The integrity commissioner can then do the vetting for bad faith, vexatious, frivolous, timeliness as well. That would be the case. You can also engage in some sort of, and as we talked about, maybe adding a step 0, essentially a pre-complaint process. One thing I want to add is we can squeeze in a pre-complaint process. That process can still occur even within the 20 days, even when it lands on the shores of the integrity commissioner. And it's really up to the parties to tell the integrity commissioner, hey, we're still trying to work this out. Can you delay your investigation? But remember, the integrity commissioner has some timelines they have to meet as well. So, my recommendation is for the, and I'm not talking about the pre-complaint procedure, is to simply have the receiving trustee be moving it through the process, right? Filing it with the email account, and then making sure the staff files it within 20 days. So that's one piece. The role of the chair in a trustee to trustee complaint, my recommendation is that there be some discretion for the chair to engage in some action, if not some mediation, but there's certainly no requirement to do so. I should also suggest, if it sounds like we are working toward a pre-complaint process, that it be voluntary, so people have the option of engaging in that. If there is some sort of committee that's set up, I suggest it be kept small, because you want to have a very nimble process. And trying to schedule these type of meetings will delay things. And also, you cannot be on the discipline committee, or at least dealing with that particular complaint, if you are a potential witness or have some sort of conflict of interest. So if you set up a committee structure, which I think will be a bit of a challenge and may delay things, it will have to be very nimble and make sure that there are no conflicts there. So our overall recommendation is the trustee who's receiving it from a staff member or public will be simply a conveyor, carrier, flow through.
Any discussion on this point? I'm not seeing any hands online, but I'm Trustee McLean, please go ahead.
Thank you, and through the chair. Is it possible to have the chair of the board fulfill this role upon receipt of the form the complainant filled out through the email account? Like, I'm concerned that someone's going to drop the ball. In essence, we're going to create this expectation that you serve no role other than to move the paper around. And if you're serving no role, then why we create the potential that at some point that this could be problematic and someone could overstep and give an opinion and somehow damage the process. If the point is really to get the complainant to the chair, can the chair not be the trustee who acknowledges the complaint and then meets that criteria?
Through the chair, what we are contemplating is that the chair will need support from staff in the chair's office or the board services office to monitor the email. And so the regulation essentially says the chair will be sending a copy to the director, to the board of trustees, to the recipient, and so on. So essentially that should be supported by a staff member. So we'll have to make those arrangements that way. The chair should be notified every time there is a complaint coming in, so that the chair would have to work with the staff members monitoring that particular email. Because obviously it is responsibility, ultimately of the chair to be making sure the process occurs. What we're suggesting is behind the scenes when we implement it, that there's actually existing staff supporting, monitoring the email account and doing the distribution work. So yes, the chair will have to make sure that they are on top of receiving this information on a timely basis.
Okay, then I'm going to, again, through the chair, because I made my point poorly then. I'm trying to see if there's any merit to taking the flow-through trustee out. And when the complainant puts in their form, the chair acknowledges receipt, signs it, meets the criteria, and now we don't have anybody that has to be the flow-through person, because I'm concerned that at some point over time that someone's going to misinterpret that role and share too much, attempt to steer. I think it's a potential problem that I don't think serves a purpose. If all we're trying to do is to get the complainant to the chair and we're giving them an email mechanism to do that, can we not meet the statute of the limitation by simply having the chair acknowledge receipt of the email and then the process in essence begins?
For you, just clarification of that point. I had thought the legislation made it clear that only trustees could make complaints about trustees to go to the integrity commissioner. So this way, what we were trying to do, because we already had established in our current process that a member of the public or staff could make a complaint about trustees. The new legislation does not include a member of the public making a complaint against a trustee or a staff member making a complaint about a trustee. Directly. So the issue is we could take that completely out of this process and have a different process for a member of the public or a staff member to make a complaint against a trustee. But that isn't part of the legislation where that would automatically go to an integrity commissioner if the chair didn't solve it. At least that's my understanding. Perhaps staff could expand on that, please.
Through the chair, the regulation contemplates a trustee filing a complaint against another trustee in order to take this through this process. TSB's existing code of conduct allowed staff and members of the public to file a complaint directly to the integrity commissioner. So whether you're a trustee, a staff member, a member of the public, you contact the IC directly. With this new regulation, in order for a staff member or a member of the public to address concerns they have about a code of conduct, they essentially need to have a trustee to be their agent in a way, right? Not necessarily advocate, but just an agent. That makes it a trustee to trustee complaint. So let's say I file a complaint with you, and then you forward it to the email account that's needed. It's logged in our database. That is a complaint. You are essentially the trustee who is filing the complaint on behalf of the member or staff member or the member of the public. That's essentially your role as a flow through, for example.
Right, but then I guess I'm doubling down on my problem with this then, because when this gets to the legislation, I don't want to be, in theory, I have a problem with my colleagues' behavior that is going, and I don't have, my name's on this thing that I did this. And if what is required is a trustee's participation, I guess I'm suggesting that the chair, when they receive it, because the chair is a trustee of the board, upon receipt, they would be acknowledging this, and it would all be the same. We would be eliminating the chance that the flow through trustee would drop the ball, or that the flow through trustee would, be the named party when this ultimately goes to the integrity commissioner.
So the clarity that would be needed, as I understand it, to legal counsel would be, within the legislation as it exists now, the change, can a member of the public or a staff member launch a complaint to the chair about a trustee? That's the essence of what you're asking.
Right. That takes the flow through out and it acknowledges and starts the process, which is all we're letting the flow through person do is in essence begin the process. This would get us to the same place without putting some risks in place.
But the clarification needed, would it be in line with the legislation? Because the legislation does not speak to a member of the public or a staff member launching a complaint about a trustee. That's the point that would have to be clarified.
Through the chair, I'm personally just maybe hearing two different things, but maybe if I try to understand. I understand your concern about having a trustee being the flow through, like they're not involved at all with whatever has allegedly happened. But because of the regulation, it requires a trustee to essentially help carry the complaint forward. We could probably, and I need to think about this a little further to see if we can put into our procedure that the chair essentially takes the place of that trustee, right? So I need to think about that a little further, whether that aligns with the regulation and how that would work. But we can try to find a way in which the trustee who is receiving it from a staff member or public to not have to do that type of behind the scenes administrative work. So that's what I thought I understood from you. In terms of members of the staff and public, again, this is something that was in the the original code of conduct that you have. I am concerned about removing the ability of staff in particular from being able to file a complaint indirectly. Again, all of this will be indirectly. And if that is something the committee is considering, I think it requires a more fulsome discussion because staff
Okay.
will want to have some input.
Through the chair, I just want to be really clear. I'm not trying to make it any more difficult for any of the three, we've decided to, the public, staff, or trustees to be able to do this. And I know when I first read this, I thought when you had to go to a trustee, there was going to be a subjective element on behalf of the trustee to determine whether this had merit. So we're saying that's not the case. We're saying all they're doing is they're and I think that the flow through model is potentially problematic. And I'd be more interested in one that got the same ability of all the parties to be able to call out something that was needed to be addressed, but to do it in a mechanism that met the legislation, but didn't, I don't understand the value in the flow through person personally.
Through the chair, let me think about some way in which we can say in the procedure that by sending it to the email account, that is in effect a trustee receiving it. But again, I need to think about that a little further and make sure that we're not inadvertently.
Thank you very much. We have Trustee King and then Trustee Arts. Please go ahead, Trustee King.
Thank you, through Chair. I had the same concerns as Trustee McLean. When I read this, I originally read it as that flow through trustee would actually be gathering the information to complete and submit the form. I don't know if I interpreted that incorrectly where I picked that up, but I had the same concern about just trying to evaluate what the value of that flow through person is. So appreciate the thinking on that. I think the one place where it did come into play was if the complaint was against the chair. I think that there was an element of having some kind of objectivity or, one degree of separation from there.
Mhm.
And I'm not completely sure if that's necessary with the central email system that we're proposing. So I think there's a few things to keep thinking about in there.
Through the chair, I do understand about, in the case if there is a complaint against the chair, and this is why having staff monitor the email account and doing the distribution would be very helpful. And recall under the regulation, if it's a complaint against the chair, it's the vice chair who's essentially the recipient of the complaint. And if the complaint's against both the chair and the vice chair all together at once, then the recipient of the complaint is the trustee, any trustee, sorry. So hopefully the use of staff to support that behind the scenes implementation will address that particular concern of a complaint against a chair.
Can I just ask a follow-up question here?
Please.
Are we considering any scenario at all where that person would be emailing directly? Like, would a staff member be completing that form and emailing it to, like, sending it through that central email address themselves?
Through the chair, I am contemplating, based on the earlier discussion, that a staff member or a public can simply just email the complaint to that email account. And then if we have some wording in the procedure that says that is in effect received by a trustee, that is something I'm thinking about trying to do. I just need a little bit of time to sit down and think about making sure that complies with the regulation. Thanks.
Sure, thank you. I think just to McLean's point earlier, I agree. If there's no actual evaluation happening on the trustee part, I'm not sure what the value of that role.
Thank you.
Thank you.
Thank you very much, Trustee Arts.
Thank you, through you, Madam Chair. So two things I'm wondering about. One is, could we have something like the parent concern protocol, a one-page for trustees? In addition to the procedure, like when this is all done, ABC, here's what you do. Nice and clean, separate document. I honestly don't want to have to rely on people going back and pulling up the policy and figuring out what they're supposed to do. But it could be public facing, that this is, so people have a clear step-by-step what to expect if they're filing a complaint against the trustee. And the other thought was, in the case of a complaint against both the chair and the vice chair, would something like what we do for discipline committee, for discipline hearings, be appropriate? So for an expulsion hearing, the registrar calls together 3 trustees who don't have a conflict in that case to hear an appeal or to preside over the hearing. I expect that a complaint against both the chair and the vice chair would be rare, and would not be a process we actually had to engage in. But I mean, we do already have a process to bring a select number of trustees together to hear the merits of in the case of an appeal, to hear the merits of an appeal and why it should be considered. That's all. Thank you.
Thank you very much. More food for thought. Trustee McLean, may I pass the chair?
Please proceed.
I may be thank you, through the chair to staff. I may be the contrarian here, but the legislation for me was clear. The changes were clear. Only trustees were to bring code complaints against trustees. If that's the case, and this is what staff will investigate, there does need to be a mechanism for the public and or staff to bring a complaint against a trustee, but it would not be this process. I think that if you designate, if the complaint against is the chair, for example, and it goes to a staff member, that's not sending it to a trustee, sending it to a staff member who monitors an email box. So I think there's lots to contemplate here, but the legislation is clear. We were ahead of the game because we had an integrity commissioner. We made our policy against complaints against trustee in the code of conduct very inclusive to include members of the public, staff members. I don't even think we included that they had to be from the city of Toronto in the original complaint process. I think they could be from Timbuktu and complain of what they see online. So I think there's a lot of cleanup and tightening that we have to do, but I look forward, through you, Mr. Chair, to staff to find out what is in line with the legislation and what is not in line with the legislation that may require a different process. And I'll look forward to what staff comes back to us with. Thank you, Mr. Chair. Is there anyone further around this question, or shall we move to the next? Let's please move to the next.
Through the chair. So in this, you might recall, we may have already touched upon it actually, but in an event, in the draft, and in response to a comment that was raised at a previous meeting about, is there a way in which we can vet through vexatious, frivolous, even harassing complaints before it actually gets over to the integrity commissioner? And so we have a couple of provisions up here. So for trustees, members of the board who have identified or witnessed conduct by a member of the board that they believe contravene the code can take advantage of this particular protocol. And staff and members of the public may also provide information about alleged breach to a trustee who in turn can do that assessment based on, quote, reasonable grounds to determine whether or not to bring it forward. As I mentioned earlier, I'm not in favor of a trustee who's receiving it from the staff or a member of the public to do some sort of assessment on reasonable grounds, just given the risk that there is. So the question here is, what is the role of the trustee who receives information about alleged breach from members of staff and the public? And then if they were to do some sort of vetting based on reasonable grounds, what would the criteria be?
Okay, so it sounds like the very first option might have to be solved before we get into these further discussions. But do people have, do trustees want to provide just some comments? I'm not seeing or hearing. Please,
just-
thank you, Trustee Arts.
Thanks. Sorry, I was having trouble getting off mute. Yeah, I just personally, I don't want to have to, I don't want to do this. I want to be able to pass it on. I think there would be lots of people in that boat. I wouldn't want to dismiss, inadvertently dismiss a complaint from one side or the other. I think a clearer process for me to be able to, contact the chair and engage whichever staff yeah, it's both I can see trustees not wanting to be the flow through person necessarily, but also not wanting to derelict the duty. And I can also see, I I can also see trustees who are like, well, I don't like that person, so of course I'm going to put this forward. There's so much potential for mess here. I just think it needs to be simple and straightforward. And so there needs to be some sort of process for us to confer on this. And I honestly, I don't know what that is.
Thank you. Thank you, Trustee. It's Trustee McLean and then Trustee King.
Thank you, and through the chair. I understand, although wasn't my initial, but I understand the concept of not having someone trustee weigh in. I'm comfortable with the fact that the chair and the vice chair are going to get, when they get elected every year, they're part of their duties are, they're going to get training in this regard. And it's not going to be reasonable to train 22 of us in this to make the kind of, just to play a subjective role in this. I'm not happy with the flow through, but I'm less happy with with 22 of us having a different interpretation of what may or may not be the bar for going forward. So the if we're going to give it to the chair and the vice chair, then I think we should do that and trust that they will execute those duties to the best of their ability.
Thank you very much, Trustee King.
Thank you, through you, Chair. I also do not want to hold the responsibility of making this assessment. However, I would like to be able to point folks to something very objective as a reference. I think this is something that many of us do in our work naturally anyway, but I think feel supported by being able to point to code of conduct, being able to point to definitions, and being able to point to any considerations that we know the chair would then embark in as part of their process. I think about that as just starting to set up expectations and helping folks navigate. If we're going to have that role of being that flow through person, that's what I see that role as being, and I think those pieces would be supportive to that. So this is not my opinion. This is not my assessment. This is just letting you know as you move forward, these are some of the guiding documents or principles that might be applied. Yeah.
Thank you very much for those comments. Anything further in this particular piece? Any other trustees? Then let's move to the third, please.
Okay, next slide, please. Again, I really already explained to you the concept, so perhaps we can dive into the comments. Thanks.
So trustees, comments on whether or not there should be an ability for a trustee to seek legal reimbursement.
Through the chair, if I can just add one thing. If you adopt status quo, it will have to be adjusted because not only is there the complaint process that is dealt with right now, you will have the integrity commissioner piece and then the appeal. And then if there's a judicial review, that's there. So right now you have complaint and judicial review in your current procedure. You don't have that appeal process. So something that you have to consider if you're adopting status quo, we'll still have to make an adjustment for that piece.
Thank you very much. Trustee McLean.
Thank you, and through the chair. The only suggestion that I would make, or potential change worthy of consideration, would be that trustees wouldn't have access to this unless it went to the integrity commissioner. If it somehow got mediated by the chair and didn't reach the level of the integrity commissioner, then seeking legal counsel was probably premature, and asking the board to be responsible for that, I think is, would be inappropriate. If we're going to deem that this is reasonable, it should at least only pertain, in my estimation, to those that formally make it to the integrity commissioner and then become, are going to become part of the public record and such.
Thank you for those comments, Trustee Arts.
Thank you, through you, Madam Chair. So just to clarify, as it reads right now, these are reimbursements for the trustee, respondents' legal costs. We're reimbursing them.
Yes, that was in the old code of conduct.
Yeah. Okay. So, I think what Trustee McLean said, that this shouldn't apply unless it actually goes to the Integrity Commissioner, and then I'm not sure it should apply for. I'm not sure that it apply for somebody that the Integrity Commissioner is found to be in breach. So would only apply for a complaint that's dismissed or mitigated in the meantime. Like, I see it. I'm trying to think to the intention of the province making these changes and what they're trying to address. And that if we are like, and the ability of the Integrity Commissioner to now impose, fines and sanctions is to really, drive the point home that trustees need to be following their code of conduct. And if we're going to reimburse them, somebody who's been in breach, I think we're undermining that point.
Through the chair,
I don't know.
If staff can just move to the next slide. It's the continuation of provisions. I just want to make sure. Okay. Under E, cost shall only be reimbursed to the member. Again, it's the respondent, not someone who's filing a complaint. If the IC concludes there has been no contravention of the code, or that the member's not blameworthy. So we would continue to adopt that based on your input, that only if there was a finding of no breach would the respondent trustee who's filing a request for reimbursement be eligible for reimbursement.
Okay. Great. So then, yeah. Okay. Thank you.
And subsection 2 of that E would not apply because we no longer have the board making a determination.
Yeah, this one triggers a particular board that's in the news a lot lately, where there's been repeated breaches, and the trustee has taken the board to court, and then is now seeking reimbursement, and has a very public GoFundMe and things like that. Yeah, so I don't know. Okay. So as written is fine, and what Trustee McLean said.
Thank you very much, Trustee Arts. Trustee Patel.
Thank you, Madam Chair. And to you, Madam Chair, a quick question of clarification since we are talking about reimbursement. This is just a hypothetical question. Let's see, a complaint comes against a trustee in a wrongful way, or that particular trustee, complaint comes against him more oftenly to silence his voice or whatever it is. And he's repeatedly found, not in breach of code. Is there a potential chance of defamation in certain cases?
No.
Okay. That's the clarification I needed.
Through the chair, that would have to be a decision of the individual trustee with hopefully their own legal advice to determine whether they want to pursue a defamation claim against the complainant.
And but my concern is to you, Madam Chair, to Associate Director. What if the complainant is a trustee against a trustee?
Through the chair, a trustee can, as long as the trustee can identify a potential provision of the code that has been breached, of course, they can try to submit a complaint as long as they can identify a potential breach of the code, sorry. And that would be up to the IC to make a determination.
So through you, Madam Chair, I just want to be crystal clear. There is a chance of potential lawsuit for defamation.
That's not, respectfully, Trustee Patel, that's not what we're discussing. We're discussing breaches of the code of conduct.
I do understand that, but sometimes I've been listening to the whole conversation, what's going on. So my concern is this, that if we target, or if somebody is targeted, or if somebody targets our trustee again and again and again, does that particular trustee, if he's found not breaching a code of conduct all the time, can he go to court for defamation? And that's a potential threat I see when there's a witch hunt.
Through the chair.
Yes.
Please.
Through the chair, nothing in the regulation or our current or even our old code of conduct prevents a trustee from pursuing legal action for any kind outside of the code of conduct process.
Fair enough. Fair enough. Thank you. Thank you so much. Thank you, Madam Chair.
Thank you. Thank you, Trustee Patel. I'd like to pass the chair.
Please proceed.
Thank you very much. Because of the number of steps now involved in this process, this particular, the way it's written now, talked about up to 5,000 for any investigation. Then it talked about up to 20,000 for a judicial review application. So it does have to be changed. I agree with my colleagues that the up to 5,000, if it's a case before the Integrity Commissioner, they rule that the trustee was not found to be in breach, I would support that. I am not sure. I guess I'd like to hear much more conversation about the $20,000 up to $20,000 in terms of the next round of an appeal.
Mm-hmm.
I support the initial, especially if it's public, they've been found to be not in breach of code. I can see reimbursement for those legal fees to clear their name. I understand that completely. I am not sure about the steps that an individual would go to support an appeal, because it also contemplates the board could do an appeal. And if the board does an appeal, obviously the board itself would infer costs. So I'm thinking we might need some more understanding about what those costs might be, what reasonable costs might be in terms of an appeal, because I'm not sure about where the $20,000 figure comes from, if it's reasonable, if it's not reasonable. So I'm looking for perhaps more information from staff. Then the other place, I guess, I would like to understand is, would this be part of the board's budget in terms of governance, or would it be part of the board's budget in terms of legal? Where would it fit within the board's budget? I think we'd have to spell that out to be publicly accountable. Thank you. Those are my questions on this. I'll take back the chair. to see if anyone else has any more questions on this point. I'm not seeing or hearing any. Associate Director, would you like to wrap up this state part?
Thank you very much. Just so that I can get some direction going forward in updating a draft on this particular issue. I'm understanding that there is some support for legal reimbursement. There's the investigation stage, there's an appeal stage, which is brand new, by the way, and then the judicial review stage. In terms of costs, it's really difficult to pin a cost because depending on who the lawyer you hire, what directions the trustee will be giving to their lawyer to do what. Usually judicial reviews are slightly less costly than an appeal, generally speaking. However, judicial reviews are very rare, like extremely rare. So I don't anticipate that happening often, if at all. I do anticipate appeals will be quite regular. And so I can tell you the legal department does not have a budget for this. I am not aware of what the funding source is, and that's why we've had it as a discussion question rather than something we've put into a draft, because this will have to be built into the board budget discussions. It is a potentially significant cost in my particular view. 5,000 for investigation. Remember, these numbers were put together with the original draft of the code over 10 years ago. I find it relatively low, but at the same time, at least it provides some sort of access to some legal support during an investigation. Better than nothing.
Thank you. I have Trustee McLean and then Trustee Arts.
Thank you, and through the chair. Trustee Laskin raised an interesting issue about something we haven't decided yet, and the whole notion about whether the board should have the ability to appeal and be inclined to appeal. And I agree we should deal with that because I think that's going to be a contentious thing. But I do think that before we were to finalize this, we would have to have that discussion to really understand. Because if we started to take that on, then this starts to add up pretty quick. And unlike the past experience where no one has accessed any of these before, if we start suggesting that there's going to be an expectation for the board to defend its colleagues, and then we're going to pay for the right to do that, then this would start to add up in a hurry and has the potential to become a significant portion of funds. So I'm very concerned about the expectation of what our colleagues are going to be expected to do in support of one another. But I appreciate that's down the road, but I do think that until we settled on that, this becomes a little premature.
Thank you, Associate Director, or shall I go to Trustee Arts?
If you don't mind, I just want to clarify.
Please.
So 6.5.1 and the regulation says that either the board or the trustee whose conduct is the subject of the complaint of the Integrity Commissioner's determination may appeal the determination. So there is it doesn't need to be settled anymore because the law actually allows either the board or the trustee who is the subject of the complaint to appeal Integrity Commissioner determination. They can appeal the finding of the investigation or they can appeal the sanction that's imposed, or both.
But through the chair, but we could, when we got there, suggest that if the board was going to do that, it would be waiving this as opposed to individual trustees who might be able to access, like this might be available. We might, depending on what we choose to, how we choose to deal with how we're collectively going to pursue these, we could then at that point suggest that the board would not be able to alleviate itself of these and that we would have to, deal with that, and that this would only be for individual trustees who found themselves in a situation where they were being falsely accused, in essence, of breaches, and allow them potential relief from the, litigation fees that they've had to pay. So I still think but I appreciate that the option exists, but how we're going to deal with that option, I think is very much in play.
Through the chair, if I can suggest that because it is probably quite complex, that to avoid being even further delayed in having a complaint procedure, we can move ahead with a complaint procedure, but earmark or bookmark, whatever you call it, additional
back to the
discussions
funding.
on this. And because, for example, it's in contemplating the current language contemplates a board would make a decision on how much, how and when, and so on, and strangely requires a report from the general counsel, which I find very odd, I have to say. Maybe we can have further discussions on, perhaps a discipline committee type committee could be the ones who does the assessment of potential requests for reimbursement. Who knows? Rather than having all 22 debate it in a private session. So for the sake of moving the complaint procedure forward, if we can park this off to the side and update it once we come to a recommendation that's approved by the board. I think Vitaly, you will be able to build in a pre-complaint process into the next draft.
Thank you, Trustee Arts.
Just a clarification question. If a trustee decides to appeal, like if they're found in breach and then they decide to appeal that, who pays for that appeal? I mean, obviously if the board is appealing, then the board is paying, but is the individual member then responsible for paying for the appeal process?
Through the chair, a trustee who's recipient of a complaint, is the respondent would be, of course, responsible for paying if they choose to retain a lawyer to help them through the appeal. These provisions are about a reimbursement of their costs if they are found not in violation of the code of conduct. So the regulation does not address this at all. This is simply a TDSB trustee determined set of provisions.
Right, but I'm just thinking that if somebody's found in breach, it was just clarification. If somebody's found in breach and they decide to appeal, because the ministry hasn't put together the panels, like the roster of ICs that they said, and we don't know when it's coming. Mm-hmm. And but there is the opportunity to appeal, but that's a panel of 3 ICs. It's going to be expensive.
Through the chair, I don't disagree with you. I think the appeal will be where the heart of the work will lie for a trustee. I do think if you continue to apply the provision that says only if you're found not in breach of the code, or only if the appeal is in your favor, only if the judicial review decision's in your favor, would you consider a reimbursement, and then the amount that's reimbursed is really again subject to. I highly recommend that the board develop some criteria, but I think having some sort of thing that says we're not going to reward individuals who are found in breach at any step, whether investigation, appeal, or judicial review, I think that's wise to do so.
Right. Yes. Thank you.
But
Sorry, Trustee McLean.
just to follow up, and I'm fine with the legal, but I'm curious, as the legislation is written, the claim was against me. I was found to be in breach. I challenge. I go to the appeal process. Does the TDSB at any point in that proceeding get a bill? Or who gets the bill? Who pays the 3 ICs that sit on that whole process? Who pays for that process?
Through the chair, the school board would be paying for the cost of the 3 IC panel. The trustee who is filing the appeal will pay for their own legal costs. But the mechanism, the process of having the 3 independent panel members, all the school boards across Ontario will be bearing those costs.
The legislation makes it clear that school boards are responsible for the cost of these.
So we pay anyway.
Correct.
Oh, good. Yay. Okay. Thanks.
Thank you. Thank you, everyone, for this discussion. I hope staff, we've provided you with next step direction. We really appreciate the speed at which you're doing this work because we understand the importance of getting this section, at least of the procedures done so that the public is very aware of what next steps are.
Okay.
And I think we have a next meeting scheduled. Do you know the date of the next meeting right now?
2 weeks today, isn't
Is it 2 weeks?
Okay.
it? I don't know.
Okay.
That's during March break.
That's the break.
Okay, so it's 3 weeks from today,
I don't have it in my calendar.
March 20th.
Trustee Laskin,
Yes,
sorry, just, can I take 2 minutes before we?
Yeah.
So I just want
before
to,
adjournment, please.
yes,
go ahead.
please. I just want to convey some conversations that happened this past weekend at OBSPA. There were a number of different boards were comparing notes about the types of committees that school boards have. And this is in regards to the mandatory attendance for full board meetings or regular board meetings and committees of the whole. So every board looks different in the types of committees that they have. And some boards, because as small ones, all their committees are committee of the whole. So I would say it sounded like most boards are right now engaging in a review and a change of their committee structures to take the onus off of the mandatory attendance piece. We have one committee of the whole as PPC. I know PPC wasn't always a committee of the whole, but a question that popped into my head, and this is not for, I know we were trying to finish the code of conduct first, and then we'll move on to the meeting stuff. But one of the questions that popped into my head is because the staff, because we approved a change to the board reporting structure, it raised the question of if our current committee structure actually fits that reporting structure. If there's a significant change. And I don't think that's something that as trustees we could just go and decide. I think that needs back and forth with staff. So just planting that bug for when the committee gets to the mandatory attendance part.
Thank you very much, Trustee Arts. Can I have a motion to adjourn, please? Trustee McLean, seconded by?
Trustee Patel.
You're not on the committee.
Oh,
Trustee
sorry.
Trustee
Trustee
Williams.
Oh, okay.
Thank you very much. Thank you. All in favor? Thank you
Aye.
very much. See you in a few weeks.
Thank you.
Thank you, everyone.